Hello, it's my pleasure to welcome you to this webinar on defending mortgage possession proceedings for the Housing Law Practitioners Association. My name's Sam Madge-Wyld and I'm a barrister practicing at Tanfield Chambers, and defending mortgage possessions are one of my specialisms, and I'm also the co-author of Legal Action Group's Defending Possession Proceedings, and it's been my pleasure, or not pleasure, depending on which way you look at it, to have just rewritten the chapters on mortgage possession proceedings for the next edition of the book, which hopefully I'm told shall be published by the end of the year. Now, the purpose of this webinar is to give people who represent or advise borrowers with mortgages secured against residential property an overview of the defences that can be used against lenders who want to recover possession of the borrower's home in order to recover the sum that's been advanced. I wish to stress that it is not intended to be an exhaustive and detailed analysis of all of the defences, let alone some of the defences available to a borrower, or indeed a comprehensive explanation on the law of mortgages. That would take days, if not weeks, to do. And we're limited to an hour, hour and a half. And indeed, you'd all be tearing your hair out if you had to sit through a webinar on absolutely everything. But what the aim of this webinar is to do is to make you aware of the types of defences that are available, and focusing in slightly more detail on the day-to-day offences that are most likely to be utilised at a first hearing for possession. Now, the predominant focus of the webinar then is how to prevent the immediate threat of a possession order and the loss of the home. However, it's important that anyone advising borrowers facing a claim for possession needs to be aware of the wider context in which these claims arise. Often, defeating a claim for possession may only result in a short stay of execution, and it could even sometimes be preferable for the borrower to give up possession, albeit on their own terms, i.e. by them selling the property so as to raise the sums that are owed, if the mortgage happens to no longer be affordable or is unlikely to ever be repaid. It's always worth bearing in mind that a defeated lender who leaves court without a possession order at all, and I'm not talking about a suspended order, but leaves with nothing, will in most cases have other remedies, such as obtaining an order for sale and sometimes bankrupting the borrower, which in the long run will probably result in the borrower losing their home. It's therefore important, and whilst it's not the purpose of today, that those practicing in this area need to make themselves aware of the bigger picture. Although this webinar is aimed at defending possession proceedings in court, in some cases, negotiation out of court, coupled with a threat of bad publicity by a complaint to the Financial Conduct Authority or the Financial Services Ombudsman against high street banks with an established brand, can sometimes have a better chance of resulting in the borrower retaining their home than would any defence to a possession claim. So it's always worth bearing that in mind, and having regard to the rules that regulate the conduct of high street banks and other lenders operating under the regulation of the Financial Conduct Authority. That being said, most of your clients will come to you facing the immediate threat of a possession claim, if not on the day, then maybe a few days before, and clearly resisting that claim will be the primary aim. And therefore, that is obviously what this webinar will be focusing on. The structure of the webinar will therefore hopefully give you an overview of the following subjects. First of all, we'll look at very briefly the different types of mortgage that there are, the statutory regulation of mortgages, then look at the defences that are available to a borrower, and finally, the remedies that might be available once a possession order has been made. But most of today will be focusing on 2 and 3. And just before we do begin and come and have a look at the slides, I want to start with a quote from Lord Macnaghten, which has been in Defending Possession Proceedings, I think, since it was first written, and a quote from my predecessor writing the section, Derek McConnell. And Lord Macnaghten in 1904 said, "No one, I am sure, by light of nature, ever understood an English mortgage of real estate." And if I may be so bold, I'd say that's as true today, if not more so, than it was then. And why is it more complicated now? Well, not only do you have to have an understanding of the English law of mortgages, but nowadays you also need to have a working knowledge of real property, trusts, consumer credit law, family law, orders for sale, and even insolvency at times. And if you are not familiar with these areas at all, then I would suggest that if this is something that you are going to come back to advising on, or you're new to, it is something you are going to have to at least have a degree of knowledge about, because it's that knowledge which is going to identify the types of defences that are available to you. And hopefully that will come apparent when we go through them in more detail in a moment. But again, I'm not going to pretend that you're going to leave this webinar understanding everything or even most things to do with mortgages. Hopefully, however, this will give you enough information so that you will at least be able to identify the defences that might be available to a client of yours that faces a possession claim brought by a lender, and understand the defences that are most likely to result in your client keeping their home. So let's turn to the slides then. And first of all, I just want to flag some of the key resources, which if you are doing the duty desk at court, I would suggest that you should always be taking along with you. The first are the two possession books, which are an absolute essential if you're going to be doing this law and you don't have the knowledge at your fingertips, which quite frankly nobody does. There's the Housing Possession Duty Desk, which is done by the brilliant Simon Mullings and Sue James, recently released, and then there will be the forthcoming latest edition of Defending Possession Proceedings, where hopefully my aim is that most of the answers, if not all the answers, and the more detailed analysis is provided within the chapters on mortgage possession proceedings. So if you identify a defence, hopefully the new chapters in Defending Possession Proceedings will tell you the elements of each defence and when you can utilise it. In addition to those books, I would also suggest having those sections in the third line of the Consumer Credit Act to hand, and also what's colloquially referred to as the RAO, which is the Financial Services and Markets Act 2000 Regulated Activities Order 2001, Article 61 and 61A, and that should be 61A onwards, because that sets out the circumstances in which a mortgage will be a regulated mortgage contract, which, as you'll come to see in a moment, is vitally important now when identifying the type of defence available. And the 61A onwards sets out the articles or the exemptions to regulated mortgage contracts. And then the mortgage arrears pre-action protocol, because that is a very useful tool to at least securing an adjournment or a bit more time at a first hearing for possession, provided that the court has jurisdiction to suspend or adjourn under either the Consumer Credit Act or the Administration and Justice Act of Justice. Right, but starting then with the types of mortgages and their effect, start with the first question of what is a mortgage, and historically this was that could be a very complicated question because there are various types of arrangements which were legal mortgages. But now what we're really talking about is a legal charge, often registered against an estate in land, but it is not itself an estate in land, albeit it does give the mortgagee or the lender an immediate right to possession. And that's one of the most common things that any law student will recall about a mortgage, so that as soon as the ink is dry, the mortgagee has a right to possession. But in practice these days, of course, mortgagees don't just issue claims for possession. There are various rules that they have to comply with as to when they do. But that is still the preeminent feature of a mortgage, is that whilst it doesn't create an estate in land, a mortgagee will have a right to possession. And that instantly makes it much more difficult for a borrower to resist a claim for possession, if that is the feature of every mortgage. But as we'll see, there are ways of stopping them from doing so. It's also important to remember that the mortgage's purpose is to give security to the lender for the debt that has been advanced to the borrower. And again, so that's fundamental to how a mortgage is enforced. It should only be enforced as a means of it recovering the security for the debt given. And there's a principle we'll see in a moment, that any enforcement by a mortgagee must be in good faith. And in good faith means it must be for the purpose of recovering security. It can't just act capriciously or arbitrarily. And there are 4 particular rights of enforcement which other creditors do not have, and they're their possession, sale, point to receiver, or foreclosure. We don't need to worry about foreclosure these days because it's largely a historic remedy. It does still exist, but it's not a popular one, and is almost unheard of now. But the appointing a receiver doesn't, for various reasons, doesn't tend to arise where you have a first charge of residential property, which will be by and large the majority of the cases you're likely to see where possession is sought from a person's home. So we're not going to consider that either today. And likewise, whilst the right to sell is probably the most important right that the mortgagee has, because once a property is sold, the what's called equity of redemption is lost, which essentially means that any legal right that the borrower has in the property is extinguished. So it's vital. Once sold, that's it. It's game over. Again, most lenders nowadays recover possession first before then selling with vacant possession. And it's, whilst you need to be aware of the importance of preventing a sale, in most cases, preventing the claim for possession will result in property not being sold immediately. There will always be exceptions, but again, the main focus for you will be on initially resisting possession. It's also important just to note at this stage, before we come to have a look at regulated mortgage contracts, that whilst you'll probably be aware of case law which establishes that mortgagees can recover possession without a court order, nowadays that's rare in the case of regulated mortgage contracts, because Section 126 of the Consumer Credit Act 1974 provides that a mortgagee cannot enforce a mortgage other than by order of the court. The remedies available if the mortgagee breaches Section 126 aren't great. You're essentially limited to getting an injunction, and if the property has already been sold or contracts have been exchanged, then you're not going to get an injunction. But it does mean that the majority of mortgagees will seek an order of the court before recovering possession or selling the property, and is why you just don't tend to get these days possession being recovered without a court order. You're probably all familiar with the various types of mortgages. Indeed, there are lots of other types than this, and many financial products on the market. but you do need to be aware when looking at the mortgage that your client has as to whether it is a capital and interest repayment, or it's interest only, or it's a bridging loan or an all monies charge, because it will have a bearing on the defence. For example, certain types of bridging loans are regulated mortgage contracts, whilst others aren't. So unfortunately, it is a good idea to familiarise yourself with the type of mortgage that you've got before proceeding on seeing what the defence is. Now, moving on to the statutory regulation of mortgages, and I'd suggest that this is a bit which you're probably going to have to pause, rewind, listen to me again, pause, rewind, listen to me again, and maybe you'll reach a conclusion as to what I'm talking about after 2 or 3 rewinds. But I'm afraid to say that there's no getting away from the fact that this part of the webinar is not the most interesting, and it's also incredibly complicated. It's something which, if you are going to be doing this a lot of the time, for the most part, there are, as I'll explain in a moment, a number of generalizations, which means that you don't always have to read the RAO to understand whether or not various exceptions apply. But in some instances, you are going to have to read in a probably darkened room with a wet towel around your head the RAO to see if a mortgage is in fact a regulated mortgage contract or not. And this is because the types of defences available depend on how the mortgage is regulated. And you nowadays have, generally, there are 3 main types of mortgage. And that's, you've got a regulated mortgage contract, a regulated consumer credit agreement, or an unregulated agreement, because it meets the definitions of a number of exemptions in the RAO, which mean it's not a regulated mortgage contract or regulated consumer credit agreement. Now, before going on to have a look at what a regulated mortgage contract is, say it is fortunately possible to tentatively suggest that these following generalizations are likely to apply in most cases. The first is that a mortgage granted on or after the 26th of March 2016 that is secured against a dwelling is likely to be a regulated mortgage contract. Likewise, a mortgage that was granted between the 31st of October 2004 and the 20th of March 2016, which is also secured against a dwelling, is also likely to be a regulated mortgage contract, unless when it was granted, it was a second charge and an exempt agreement. And this is because the change in the law that took place on the 21st of March 2016 retrospectively made agreements that were not previously regulated mortgage contracts into regulated mortgage contracts, but only if they were previously regulated consumer credit agreements. And so that means that you have to consider the law before and after 20th of March 2016. But in the previously, it had been the case that if you had a first charge of a dwelling, then that was also, and it was granted after the 31st of October 2004, then that also was a regulated mortgage contract. But so most mortgages of dwellings that post date the 31st of October 2004 are likely to be regulated mortgage contracts, subject to a couple of exceptions, which we'll look at in a moment. In respect of mortgages granted before the 31st of October 2004, where you have a dwelling, that is unlikely to be a regulated mortgage contract. It's also unlikely to be a regulated consumer credit agreement. And that will have a bearing on the types of defences that can be run. So, regulated mortgage contracts. The definition of what is a regulated mortgage contract is generally set out in Article 61.3 of the RAO, But it's also important, and again, this will almost certainly be satisfied in most cases, that it has been granted by a person by way of business. So one-off transactions, where it be by friends or relatives, don't tend to be caught and don't tend to be regulated mortgage contracts. Set out in the slides, by way of business, it generally means what you'd expect it to mean, view to making a profit over a period of time, but it can include one-off transactions if in the course of a business carried out by a business which is doing other things. So the crucial definition, which is in Article 61, and this applies to mortgages that were granted on or after 21st of March 2016, is if at the time it is entered into, so it's got to be at the time, it makes provision for a person to provide credit. Okay, that's going to apply when you have a mortgage, and again, obligation of the borrower to repay the credit secured by a mortgage, so that's going to be satisfied in all cases. Then you have at least 40% of the land to be secured is used or is intended to be used where the credit's been provided to an individual or in connection with a dwelling. And the same applies where you've got credit provided to a trustee. Now, you'll note a few important points there. There's no requirement that the land be used as a dwelling by a borrower, just that it is intended to be used as a dwelling. And also that it does have to either be used or intended to be used as a dwelling. If it's not going to be used as a dwelling, for example, it's going to be left empty and no one is intended to live there, then it won't satisfy the test. And you also have to have at least 40% of the land. So if you had a huge plot of land and a house on it, but when you looked at the land and the land was, say, 75% and the house with its garden was only 25%, then you wouldn't have a regulated mortgage contract. But in almost all cases that you will be dealing with, whereas possession of residential land, it's almost certainly likely to have at least 40% of the land secured, being used as a dwelling in which the mortgage is secured against. Now, as I said earlier, the complicating factor from this is that there are various types of mortgages which are not covered, and I'm not going to go through the detail now, just because it's too complicated to try and read out in a webinar. But you need to have a look at Article 61A of the RAO. And again, you can make some tentative generalizations. Tends to be first charges, although again, this doesn't always apply, but it tends to be first charges don't tend to be exempted agreements. So first charges tend to be regulated mortgage contracts. If you've got a second charge, then the types of exceptions like the business loan or certain bridging loans or buy-to-let mortgage contracts, where they are second charges, there is a chance that they will be exempted. But detailed provisions, such as with the bridging loans, it depends on how many repayments there are. And in respect of the business loan, you have to have credit that's exceeding £25,000 along with other requirements. But you just need to be aware of, just think, well, is this a bridging loan? Is this a buy-to-let mortgage? And if those alarm bells are ringing, then you just need to go to Article 61A to have a look to see whether or not it is exempted from being a regulated mortgage contract. So now moving on to the pre-2016 regulated mortgage contracts. Since the 31st of October 2004, first charges of dwellings, unless they are exempt by the RAO, were regulated mortgage contracts, but this excluded second charges of which were secured against dwellings. But these types of mortgages could be regulated consumer credit agreements. Now, to make matters unhelpfully complicated, a mortgage that was a regulated consumer credit agreement when it was granted has now become a regulated mortgage contract. If it would have been a regulated mortgage contract if it had been granted after the 20th of March 2016, even if it was actually granted before 20th of March 2016, and at that time wasn't a regulated mortgage contract. And that's because the RAO has provided that essentially second charges of dwellings which otherwise satisfy the definition of a regulated mortgage contract pre-2016 should now be regulated mortgage contracts. And so this means that generally most mortgages of dwelling granted between 31st of October and 2004 and 20th of March 2016, if secured against a dwelling, are now regulated mortgage contracts, even if they weren't pre-March 2016. But the one exception, and the key exception to that, is that if it wasn't a regulated consumer credit agreement prior to March 2016 at the date of its grant, then it can't be a regulated mortgage contract. And there are two scenarios which I've set out on the slides, which are the most common reasons for mortgages not being regulated agreements and therefore not being regulated mortgage contracts. The first is where the mortgage was granted pre-April 2014 and it's a second charge, and the amount of the credit loaned either exceeded £25,000, £15,000 or £5,000, depending on when the mortgage was granted. And that's because prior to April 2014, there was a credit limit which changed over time. But essentially, if you had a mortgage which was securing a sum above those limits, then it couldn't be a regulated agreement. Now, the law changed in April 2014 and the credit limit was abolished. But because the credit limit was abolished, there was a new exception applied, which is where you had credit being advanced that exceeded £25,000 and the loan was for the purpose of a business, then it was an exempt or unregulated agreement. And there were a fair number of those types of loans. And indeed, as case law has shown, there are a fair number of those loans in which the borrower has allegedly asserted to the lender that they weren't living in the property as their home, and the loan wasn't for the purpose of a business, who have turned around and said, actually, I am living in the home, and therefore it's a regulated agreement. And the lender, said no, it's an unregulated agreement. There's been quite a lot of litigation about that, but those are the two common reasons for a mortgage not being a regulated agreement and therefore now not being a regulated mortgage contract. If you have a mortgage that isn't a regulated mortgage contract, it will either be a regulated agreement or an exempt agreement. And there's no real distinction between a regulated mortgage contract and a regulated agreement. The Part 9 of the Consumer Credit Act, which gives the court various powers, for example, to suspend possession orders or change the terms of the mortgage, applies to both regulated mortgage contracts and regulated agreements. But probably the most important distinction is that the really extensive unfair credit relationship powers do not apply to regulated mortgage contracts. And therefore, while on the one hand, the change in the law in March 2016, which looked to bring a whole range of new mortgages into the control of the Consumer Credit Act, or the overview of the Consumer Credit Act, one of the most powerful remedies a judge has in respect of unfair credit relationships has been excluded. So in a way, you're now in a better position if you have a regulated agreement rather than a regulated mortgage contract, because you have the full gamut of Part 9, whereas with a regulated mortgage contract, you're limited to time orders and the possession orders being suspended. We'll come on to that in a moment. And it's also worth noting on the final bullet on this slide that unfair credit relationship powers actually also apply to exempt agreements, whereas other parts of the consumer credit don't apply. But the circumstances, I say, in which you're likely to have an exempt agreement are not likely to be that common nowadays, where you have residential land, but still worth keeping an eye out for them. So why is it important to identify if you have a regulated mortgage contract? And I've alluded to some of these so far in talk, but there are two quite important potential defences. The first, which is not that common, but does arise, and I've certainly advised on a few of these, is that if you have a mortgage that is a regulated mortgage contract and it has been granted by a person, whether a company or an individual, that is not regulated by the FCA, then it is unenforceable unless the court exercises a discretion to say that it is. And that's under FSMA, which is the Financial Services and Markets Act 2000. And that is a potentially brilliant defence to claim for possession, because clearly if the mortgage is not enforceable, then the mortgagee does not have a right of possession, and that's a complete defence to the claim. It's worth bearing in mind, however, that that seems like that's absolutely amazing, but if it's unenforceable and the borrower elects not to perform the agreement, i.e. decides not to pay back any of the sum advanced or the interest and the cost, then FSMA provides that the borrower must still repay the sums advanced. So it's sort of what you call counter restitution. And often the only way that the borrower is going to be able to find the sum advance is to sell the property, and that's not necessarily going to help too much. But it's always worth having this in mind, because there are, and again, it's not really been decided yet, because there's not been a case on this where it's been crucial, but it's likely that if the lender faced with a situation where they can't enforce the mortgage, if they want the borrower to repay the loan, they're going to have to bring a claim. And there's a reasonable argument that any such claim would be a claim for a sum of money payable under an enactment, and that such a claim has a limitation period of 6 years. And so if 6 years have passed since the borrower decided that they weren't going to perform the loan by repaying it, and that the mortgage has become enforceable, and you could argue that the lender is out of time to bring a claim for the sums being repaid. So whilst it's unlikely to be that common, it's worth bearing this in mind, because you might be able to establish that the mortgage is entirely unenforceable and the time for the lender to recover the sums from the borrower has passed and their time bar. The other relevance of a mortgage being a regulated mortgage contract is, as what I've alluded to previously, is that Part 9 of the Consumer Credit Act applies, and we'll look at that in more detail in a moment.